You are on bond for DWI, and you've now picked up a new.
Okay, wait. Did he just pick up a second DWI while already out on bond for the first? That's like showing up to traffic court in a stolen car. If there's one way to lose the judge's sympathy, it's this.
DWI. Sir. You were charged again. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On April 24th, 2025, in Harris County, Texas, law enforcement officers were dispatched to a crash. The law enforcement officers spoke with a complaining witness who stated he had gone to the bathroom and heard the defendant crash into the bus. The complaining witness was the bus driver. The complaining witness estimated the damages to be $1,000. Another witness saw the defendant strike the bus, get stuck between the bus and another vehicle, and then
Picture this. You crash into a bus, wedge your car between two vehicles, then try to Hulk push it out, and run off when someone threatens to call the cop. This is not just a DWI. This is a full episode of World's Dumbest Criminals.
At the driver's side door and tried to push the vehicle out. The witness stated after another individual told the defendant they were calling the police, the defendant fled. Another law enforcement officer was alerted to the incident and found the defendant, who matched the description given. A witness was able to identify the defendant as the individual driving the vehicle that struck the bus. Another law enforcement officer made contact with the defendant, who stated he was coming from an Astros game where he drank. The law enforcement officer observed a moderate odor of alcoholic beverage, glossy eyes, and profuse sweat from the defendant. The defendant refused to cooperate on standard field sobriety tests. The defendant refused to provide a specimen. A blood warrant was obtained and executed.
Mr. Gallegos, I'm going to find that there's sufficient probable cause to go forward with the case. I'm now taking away your privilege to drive. You are not allowed to drive.
Let's talk about that scram monitor. It detects even tiny amounts of alcohol through your sweat. Combine that with a GPS on the other ankle and a curfew, the judge basically turned him into a walking parole bracelet. This is not a slap on the wrist. It's digital lockdown.
Drive at all. Do you understand me? On one ankle, I'm going to put a scram monitor so I know that you're not consuming alcohol. On your other ankle, you will get a GPS monitor, and I'm giving you a curfew because I don't want you out in the middle of the night. And if I find that you're out, I will revoke your bond and make it extremely high. He's on bond for this DWI.
Yes,
I'm
sir.
revoking his bond. You're going to jail today.
Right now?
Right now.
Okay, as far as the monitors, can we waive
So-
the fees?
Absolutely.
Of course.
Can you get my stuff to my mom?
Yes.
So these are conditions. We'll have him sign now. The GPS monitor prior to release.
Are you setting the bond?
Of course. Mr. Gallegos, I want you to understand something. This is an affidavit that you're going to sign for me, that you're going to promise to me you're not going to drive. I don't give a rat's behind what your excuse is. If Jesus comes from heaven and needed to ride to church, you drive. I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500.
And here comes the courtroom moment that always gets clipped on TikTok. If Jesus needs a ride to church, do not drive him. That's not just a threat, that's a legal commandment. This judge is not just laying down the law, he's carving it in stone.
Fine every time you drive. Do you understand? I am now also sending notice to DPS that I'm placing a restriction on, you're not allowed to drive, but I'm placing an additional restriction on your license that you are not allowed to drive any vehicle that doesn't have an ignition interlock on it. This notice is sent to DPS so that every single officer in the state knows that if you are in a vehicle driving, they pull you over, you don't have an interlock, they will take you to jail. Do you understand? As it stands, you are not allowed to drive for any reason. Okay, we'll have him sign this. We'll put him in back. Rocks in. What the
Presumptive positive for THC.
That's it. Okay. I'm giving you a pass for 50 days from the time that we ordered you not to use. Don't use. Do you understand? So we ordered him not to use when? He's still testing positive. We ordered him not to use in January.
Well, he tested positive on April 7th, or not, on April 14th, rather.
Okay, but he's still testing positive. He's still using when we ordered him not to use.
Yes, but I understand that THC can take up to 30 days to work out of urine, so there's no evidence that he's been using beyond the
I ordered him not. Let me see. Hold on. I ordered him not to use in January. We are now.
Yes, Judge, but you've already addressed his drug use that resulted in the positive result on the April 14th drug test. You addressed that by chastising him in court and issuing several additional bond conditions. There's been no evidence that there's been any additional drug use for the court to address.
If I tested him in early January, then I'm going to have an issue. But if it's the first time I tested him was in April.
Now here's where things get legally murky. THC can linger in your system for weeks, but the judge is laser focused on when the no-use order began. If this timeline does not line up, the defendant could go from probation to punishment real fast.
April, then I'm going to give him the 50 days from the first time that we tested him. But if I tested him early on and he tested positive and I admonished him not to use and he's still testing positive, I'm going to have an issue. I don't remember when the first time we tested him, so I'm going to ask her. Roxanne, on Mr. Hernandez, when was the first time we tested him, please?
When he first tested positive for THC?
Yeah, when did we first test him?
Oh, it was March 11th of this year.
Oh. So March 11th was the first test, and that was positive or
Negative.
that was negative.
Yes, it was negative. And then on April 7th is when it was a no-show. And on April 14th, it was confirmed by that he was positive for
No,
THC.
you're using. I'm sorry. I'm revoking your bond. You're going into custody.
I could just ask the court to so Mr. Hernandez's mother is out in the hallway. I'm certain that she's going to pay whatever the bond is. This revoking the bond here will only have the effect of punishing his mother, who will have to pay the bond. And I'd also just ask the judge you to consider that I understand that there may be evidence that he's used since he was ordered to not use it. I understand that, but there's no evidence that he's using now or that he has used in the more than 2 weeks since the prior drug test.
We just tested him yesterday. He tested positive. He tested positive a week ago. I've ordered him not to use. I mean, if I don't, then I'm rewarding him for his behavior, Mr. Schlossberg. That doesn't make any sense. You know, I understand that it's punishing mom. These are the things that you need to consider when you're out there. I told you not to use, and you're now using. Goes with you. I'm sorry, Mr. Schlossberg. I can't just continue to let people go.
Judge, the drug test yesterday, it came back positive for THC because it was within 14 days of the previous drug test.
The judge finally lays it down. If I do not act, I am enabling the behavior. And honestly, he's right. This is not just about drug use. It's about accountability. You cannot show up high after being told not to and expect a free pass. Courtroom mercy has its limits.
14.
He tested negative the first time we tested him, and now he tested positive for using marijuana. That's it. There's no, I mean, really. If I don't, I'm enabling the behavior, and that's it.